House Bill 278 by Representative Edmonston provides rules for live streaming proceedings in the family court for East Baton Rouge Parish. We do have a set of amendments. Thank you.
Vice Chair Edmondson, you want her to go ahead and read the amendments in?
Do you want to
Like
do
Ms.
the...
Winfrey to read the amendments in? Ms. Winfrey?
Okay. So the amendment set is 2877. And what they do is they delete the requirement that the proceedings be live streamed and video recorded. They provide that the proceedings be audio recorded, and they change the effective date to August 1st, 2026.
You move to adopt the amendments?
Yes, I do. Ms. Winfrey, you just read in the amendments that pretty much changed the bill, correct? Okay. Yes. Did everyone get a copy of the amended bill? Because we were going to, the amendments, so that they'll know what we're looking at. Yeah, it should have been before.
They won't have that, Kathy. They don't have that. Can they each get a copy of that?
Can I get a copy?
Can the members get a
Yeah,
copy?
I mean, I don't know. Mr. Chair, can we get a copy to all the committee members so they'll know what they're looking at? You have that, Representative Abear? Is that what you said?
It's online. It just popped up.
It just popped up online? Okay, is that suitable?
That's fine.
Thank you, sir. Okay. Thank you, Mr. Chair and committee members, for your patience in staying so late. Because of so many complaints, Senator Cleo Fields in 2024 in the regular session did a resolution, SR 81, for the Supreme Court to study the East Baton Rouge Family Court. Because I had had so many calls about the issues there, I co-authored this resolution. Supreme Court Justice Jeff Hughes, who's seated next to me, stepped up because the court was in his jurisdiction. He and I have interviewed multiple families who have been adversely affected by the actions of the court. This is why we're bringing this piece of legislation. HB 278 is being framed as an assault on abuse victims' children and privacy. It is not. This bill contains safeguards. It allows in-chambers testimony for minors in certain circumstances, permits initials or pseudonyms in custody matters, and allows closure of custody hearings upon a showing of good cause on the record and written agreement of the parties. This is what it looks like when people are trying to balance privacy with accountability. The real question is bigger. Should a court with enormous power over children, custody, support, protective orders, contempt, family integrity, and the financial survival of litigants remain so shielded from public scrutiny while families endure prolonged proceedings, escalating costs, repeated enforcement actions, and serious financial pressure? It's especially troubling when the real fears of abuse victims and the real need to protect children are used to defend secrecy rather than accountability. Those concerns certainly deserve respect, but they should not become shields that block scrutiny of a court exercising extraordinary power over families. Public accountability is not cruelty. It is a safeguard. If East Baton Rouge Family Court is functioning fairly and honorably, then measured transparency should strengthen public confidence and not threaten it. And with me I have, again, Judge Jeffrey Hughes from the Supreme Court that's going to elaborate on the bill for us.
All right. Thank you, Mr. Chair and members. Appreciate the opportunity. My name is Jeff Hughes. For the last year and a half, I've been serving as the law clerk for Representative Edmonston. I'm here to give you just some background information. As mentioned, Senate Resolution 81 from 2024 was co-authored by, at the time, Senator Cleo Fields and Representative Edmonston. For the next year and a half, I've worked with Representative Edmiston. We've received, I think, well over 100 complaints. We've talked to many attorneys. Senator Regina Barrow met with us and has been very helpful. She's kind of concentrating on the problems at DCFS, but there's a little overlap here with the family courts. HB 278 is a very simple bill. I'm not sure if y'all, and I apologize, I don't know how the process works, but there have been several amendments, but what we have is the final version. It's after all amendments are in, this is what it's going to read like. And what we're doing is addressing the two main problems, or two of the biggest problems that we see over and over again. One was closed hearings, where people were excluded from the courtroom. There's a process if someone's going to be a witness in a case called sequestration, where they are made to go outside the courtroom until they come in to testify. That's not what we're talking about. These are family, friends, simple onlookers.
Legislators.
When I was a law student, they always told me, go sit in court and watch. You know, people would just, if they weren't somebody that's connected to the case, they were excluded from the courtroom. Those included Representative Edmiston, Senator Valerie Hodges. I think Representative Zarang sent his legislative assistant up there one day to listen in, and they excluded her from the courtroom. Woody Jenkins was up there in his capacity as a journalist. He's got his Central City News and the other paper, and they, in my opinion, illegally excluded him from the courtroom. I think the reporter for the Advocate was excluded on occasion. We want courts to be open. The other related issue is status conferences. Status conferences are where the lawyers meet with the judge, usually back in chambers, although we've had reports of meetings in restaurants, just all kind of weird stuff going on. But meet with the judge, the lawyers. The clients are not there, so they don't know what's being said. The lawyers come out of the meeting and tell the client, the judge doesn't like you, and if you don't agree to her recommendation, it's going to be worse for you. Now, I know that sounds weird, but we have heard that over and over and over again. This bill provides that these status conferences must be held in open court, on the record, with the clients present, so they can hear what's being said between the judge and the lawyers, and then they can make a good decision. When people are told, you know, things are going to be worse for you if you don't agree, that's a terrible pressure to put on somebody, and it's coercion. And we hope that this would prevent that from happening, because we don't think people will say those kind of things if they know it's being recorded. Again, I'm sorry.
Good job.
No. Can I keep going?
Representative Green.
You have. Well, wait.
Well,
Again, no cameras and no cost. The system to record is already in place.
Right.
In fact, Representative Edmiston and I were recorded in the family court one day when we were the only ones in the room. I've got the recording on a thumb drive. That's all that's going to be required for the parties to go the next day or whenever, when it's practical. Get a thumb drive of what was said in court. This system is already in place. The 4 family court judges can sit in their office and listen in to any of the 4 courtrooms.
Judge, you're over the time, and the other thing, you've never put a card in. You've got to put a card in.
I'll let Justice continue
Will.
Yeah, I apologize. It's
to finish his remarks.
Got it. Okay.
I just want to let the audience know that we got 12 people that want to talk in favor and 10 who want to talk against.
He's done. You're done.
I'll listen to the boss. Thank you very much.
All right, let's start with the ones who want to talk in favor. Oh, there aren't any questions.
Okay, good.
No, I do have I do have a question.
All right, go ahead. Well, sit down.
Okay. Justice Hughes, thank you for being here. I know some of these hearings are very sensitive, and with respect to status conferences, what's to stop a party from having a court reporter being brought in chambers to allow the dialogue between the court and the parties who are present from being transcribed?
The cost, transcripts, it could be $1,000 to record a status conference. I personally purchased a transcript of a status conference, and it was lengthy, but it was like $2,000. As I say, this would be whatever the cost of this is, because the system is already in place.
My next question is, why are we?
Oh, excuse me, sir, but this has nothing to do with court reporters. If someone wants to take a writ or an appeal to the First Circuit Court of Appeal, they'd still have to go order the transcript, purchase that transcript to provide it to the Court of Appeal.
Why are we singling out just the family court of East Baton Rouge Parish and not doing this across the entire state?
It's the coercion issue. Like in a regular court, you have a car wreck case, you have a status conference. The one party says, well, Judge, my client wants $10,000 to settle this case. And maybe the lawyer for the insurance company is there. And he says, well, Judge, all we can offer is $5,000. And so the trial judge says, well, guys, why don't y'all agree to $7,500? And they'll go out in the hallway and talk, and if they can agree, fine. If not, you go ahead and have the trial. But these family court cases where it's like they very rarely actually have any witnesses on the witness stand. I mean, it's all about the backroom deals and then the coercion, and that's not a healthy situation.
And my next question is, I know the Supreme Court issues rules with respect to district courts and family courts and all courts within your jurisdiction, right? Because you guys have supervisory jurisdiction of the courts underneath you. So what's to stop the Supreme Court from issuing rules related to how lower courts, and specifically family courts, govern, as opposed to having the legislature imposing what appears to be a very specific legislation at one particular court?
Well, this court, for whatever reason, I had no knowledge of this until this resolution was passed. The resolution requested that the Supreme Court investigate and make recommendations to the legislature. And so that's pretty much what we're doing here today. I don't think if you could get the 7 justices together on something like this, and rules can always be changed. We change our rules all the time. In fact, we changed a rule that said a judge who's retired from the family court cannot go back and be a mediator in that family court, just like a month ago.
I did see that.
Legislation will be legislation. It'll be the law.
Okay, thank you.
Representative Florida.
Thank you.
Thank you, Mr. Chair. Can you tell me, as it relates to this study that the Supreme Court did on EBR's family court, what recommendations did you present?
The Supreme Court appointed Judge Jimmy Kuhn to be a supernumerary judge, which is a fancy name for a troubleshooter. He went in, he made some recommendations, but he was only there for 6 months. His recommendations, a lot of it had to do with the perception of certain attorneys had access to the judges and their law clerks. He told me some of them have lockers back in the judges' area. Other attorneys don't even know that that's possible. He recommended more training and things like that. After some more, I guess another 6 months worth of study, after Judge Kuhn was gone, he left on April 1st of 2025. By December of 2025, we had gathered enough information, and I issued also a report to Representative Evanston, had some much more specific recommendations. And these are 2 of them, to have things open and to have things recorded.
So the initial report by the Supreme Court for the super judge or whatever he was, investigator,
Yes.
right, did not have these recommendations. So are the second set of recommendations, are they recommendations from the Supreme Court?
The Supreme Court really never made any recommendations. Judge Kuhn made a report to our judicial administrator. I will tell you that none of the justices was willing to sign that report. It was signed by our judicial administrator. But it did point out some of these problems, the closing of the courtrooms, for instance. I mean, Judge Kuhn gave me a sign where they said you can only go on the fourth floor by appointment only, that type of thing. So he touched on some things. I view this as not inconsistent, but as a follow-up and more detailed study.
You used the term coercion
Yes.
earlier. Is that a specific finding from the Supreme Court's report? Was there ever a finding that coercion was happening in the EBR family court?
Again, there was a report signed by our judicial administrator, so if you want to refer to that. I think it touched, if you read the whole thing, Exhibit C, which is attached to that report, is the findings of Judge Kuhn. And he attached on that. He said there was the appearance of favoritism. And then our judicial administrator put in a footnote that said, we note that Judge Kuhn did not find that there was actual favoritism. I think that kind of red flags the issue right there.
To you. Thank you.
Thank you.
Representative Lacombe.
Justice Hughes, I'll be the first to admit I don't practice family law. I've never been in the family law court in East Baton Rouge that I can recall ever. But I have prosecuted and dealt with a lot of juvenile issues, prosecuting of juveniles, and have done multiple hundreds of sync cases, child in need of care, while I was at the district attorney's office in the 18th. And there's precedent there that all juvenile matters are usually sealed. Nobody's in the courtroom, correct?
In a child in need of care proceeding.
No public is there. Nobody's allowed. No public is allowed into the courtroom whenever you're doing those juvenile matters. Well, if not, I'll tell you, we never allowed.
Oh, yes, I guess because it's a juvenile, it's all confidential.
It was all confidential. It was juveniles. We were discussing sensitive juvenile matters. The only people that was allowed in was essentially either foster care workers or, parties that was to the case. And, I look at this when I look at this bill, and I previously talked to Representative Edmondson about it, and I kind of raised some concerns weeks ago when we were looking at this, and a lot of it stems from these children are not voluntarily there in these proceedings. They're not willful participants. They're there because their parents are getting a divorce or there's some kind of a fight in custody matters. So when I look at this, I see issues where the sensitive matters going to be discussed, potential sexual assault or molestation by parents. I see issues where these children may be discussing very issues that bedwetting and all kind of potentially embarrassing things. I don't think that the public should be subject to being in the courtroom or even be able to watch these or have access to this in any way, because that's just, these children at some point are gonna, if this becomes public or becomes out there or people are allowed to see it and witness it, the level of embarrassment to these children are just immeasurable. And so from the beginning, I've kind of had deep concerns about this. What do you say? Like, I'm looking at the bill, and I don't know if this was amended, but I'm saying it says the judge has to determine on the record that good cause exists for the custody hearing shall not be closed to the public unless all of the following occur. The judge determines on the record that good cause exists based upon evidence and that all parties agree in writing to the closing of the courtroom to the public. So that's basically a kind of wide open courtroom. I have serious reservations about that, Ms. Edmondson. I told you about that earlier.
Just going to speak to that for a minute.
Yeah.
Okay, thank you, Representative Lacombe, for that. First of all, do you know that it's been amended? There will be no cameras. Okay, so we're only talking about audio. We're only talking about the litigants and the attorneys. We're not talking about the general public. And so, if a party in a suit wants to get a copy of what went on in the courtroom, to me, they should be allowed to do that. What they do with that after is really, that's not under our control. It is the way I see it.
Okay.
So, did you have anything to add about
Well,
that?
and the parents can close the hearing totally if they want to.
It's really more about transparency in the courtroom, because we have seen so many, and you'll hear, so many families that are being destroyed, kids that are being kept from their mothers or their fathers. And it's an issue all over the nation. I don't know if you know that, but this is a huge issue all over with family court. So that's why we're bringing what we're bringing.
Representative Jordan?
Thank you, Mr. Chairman. So let me just ask a few questions, because, I mean, are family court proceedings right now, I know maybe not the status conferences, but are family court proceedings recorded currently?
Well, there's a court reporter like in any other civil case.
I would assume so.
Yeah.
So that,
Although they can go off the record and they do not record the status conferences.
right, but I'm just saying that the hearing itself is already, there's some audio of the hearing currently. Can the litigants get access to the recording or just the transcript?
No.
They have to purchase a transcript, and it is a arduous and lengthy process to actually go and listen to the audio recording.
All right. So let's, just for clarity, so what would your bill just allow them to record it, or it would allow the court to record it and then they just download the digital file? I'm trying to.
The system is already in place. They already record stuff. They recorded me and Representative Edmonston when we were the only ones in the courtroom one day. And then they can go, the parties under the bill can go and get a copy.
All right. So they would just, it's already recorded. They would just be able to get the jump drive and download the audio file.
Right.
Would there be any cost associated with that?
Whatever these little things cost, I don't know.
Okay.
Much less,
I could see where they could charge a $5 fee or a $10 fee or something, but it won't be the hundreds or thousands of dollars to get a transcript.
Right. So when they get a transcript, is there anything that's usually redacted? And that might be more so for the court reporter or the judge, maybe somebody to answer for me. But does it include redactions at all?
It can. That's kind of up to the judge and the court reporter. We've had some complaints that transcripts were altered. They didn't really reflect what was said in court. I haven't.
But this would be an unredacted version of what.
Yeah, this would be a word for word what's
right.
said in the courtroom.
Right.
But it would only be available to the parties, not the public.
Correct.
All right. All right. Thank you.
Representative Green?
Thank you, Mr. Chairman. I'm going through the report that was studying recommendations of family court for the Parish of East Baton Rouge, submitted by the Office of JA for the Supreme Court. And going through, looking at Judge Kuhn's recommendations was that the family court hire a hearing officer to make recommendations in child support cases, also to hire additional minute clerk staff. And there are also additional requirements for training for the judges of family court, things related to self-represented litigants, duty judges, the courthouse layout. And it also talked upon the closing of the courtroom, how the court has discretion to, which it can exercise if there's good cause to clear the courtroom to have a closed hearing. And so it doesn't appear as though any of these recommendations that the court issued based on this finding by Judge Kuhn been adopted.
I think that the family court amended their rule for duty judges because it looked like you could judge shop to get like a temporary restraining order. And the family court on their own changed their own rule on that. Other than that, I'm not aware of any of these being implemented.
So if we pass this bill right, that requires status conferences be held in open court, how would that comport with Article 135 of the Civil Code, which provides a custody hearing may be closed to the public?
This legislation would overrule that legislation. It would sort of reverse it and say it shall be open unless the judge and the parents agree to close it.
Okay.
And there's also the provision in this bill that the testimony of a child would be taken in chambers.
Okay. All right. Thank you.
Representative Abear?
Thank you. Look, I'll be honest with you. There's many people that tell us that family court is a problem just about anywhere else. And I think your open letter was sent to me by a constituent who was complaining about family court in my area. But I'm just going to break it down into the simplest question I can ask. How is what you're proposing here today going to improve family court?
I would hope it would prevent some of the bad practices that we have seen. If the judge, when a lawyer comes out and tells a client, the judge says, she doesn't want to hear your case today. If you don't agree to this recommendation, it's going to be worse. You'll lose whatever custody you have. We don't know if did the judge really say that? Is it the lawyer wanting to go play golf? We don't know. But if they know that it's being spoken in court and it's being recorded, I don't think they're going to continue to make those kind of statements. That's our hope. We don't, and I don't see how anybody that would be opposed to this is trying to hide something, in my opinion. I mean, this is open, be honest, put everything out there on the table, let the clients know what's going on. If you can't agree, call your first witness, go to court, put on evidence. If you don't like that, you can take an appeal. But this backroom coercion is the worst thing that we have found.
Okay, thank you.
Representative Golly?
Thank you, Mr. Chairman. So when I talk to some of my colleagues here, their biggest concern are the children. What kind of safeguards are in place to protect the kids while at the same time promoting transparency and cutting down on some of the statements we've heard about what goes on in the closed doors?
Well, as I said, if the parents agree and the judge thinks it's a good reason, they can close the hearing. The children testify, it's in chambers.
Already.
Is that recorded?
There's nothing, yes.
Yeah.
But this is an audio recording, so there's nothing there that, let's say, one of the other parties does not like the result and they're going to take an appeal to the Court of Appeal and they order a transcript. There's nothing, that's not private. Anybody can go order a transcript and pay for it and get it. They don't even have to be a party. The only people getting the recording would be the parents, the parties.
So what you're saying, the kids potentially have exposure via the transcript?
They would, as much as they will under this bill. This is more protective than there is now for the recording, because only the parties can get this recording. The transcript, you don't have to be a party. If you go pay your money, they'll give you a transcript.
And somebody mentioned redactions before. Are there any redactions in the transcript?
There shouldn't be. I mean,
There
it's
should
supposed to
not
be
be.
a record of what's happening in court. But,
But in the interest of protecting the children.
The bench conferences are not recorded. The lawyers go up to the bench and talk to the judge, and nobody can hear what they're saying. That's not going to be in a transcript. And then the status conferences, if they go back in the judge's chambers and talk about it, if they say, let's go have dinner at some restaurant and talk about the case, that's not going to be recorded. That's why we think it's important that these things all happen in the courtroom and be recorded. That's more protection for children than what's happening now.
So the scenario you just described, let's go discuss this at a restaurant. That would be on an audio recording?
No, that's
It
what's
would not.
happening now. That's what we want to prevent.
Well, okay. How does the bill prevent that?
Because the bill says that status conferences must be held in the courtroom and be recorded.
Are there rules and regulations that govern conference? I'm sorry. What are they called again?
Status conferences?
The status conferences. Are there bylaws that govern that?
They're not right now. That's what we see as the problem.
Okay. All right. Thank you.
All right, let's, that clears the board.
Okay.
Let's hear for some more
You
witnesses.
want us to move? Yeah.
Representative Jenkins, you want to come up, invite my old friend to come up to testify? Sure. When I came here in '96, he had been here about long as the Capitol's been built.
Yes, sir, Mr. Chairman.
Well, I learned a lot from you. I want to thank you for what you taught me.
Thank you, sir. Thank you.
All right.
Representative Whitney
All right, we
had
need to
mentioned that.
adopt the amendment.
Yeah.
Is there a motion to adopt? Representative Edmondson, you
I'll
moved to
make that
adopt.
motion, yes.
Any opposition? No opposition. All right, Susan Rayburn, if you would come up.
She's not in here.
You can stay there if you want to, Brett.
Oh, I'm sorry. I thought he said Susie Laborie. I'm sorry.
No, there's an empty seat, isn't there? Is there an empty seat?
Yes, there is. Yes.
Susan Rayburn, is that right?
I beg your pardon. I thought he
All right.
said Susie Laborie.
Like I say, we have about 12 people wanting
Yeah.
to testify, so.
Trying to keep
And 10
it 3 minutes.
Susans, right?
But Representative Jenkins, you want to,
Yes, sir. Thank you,
Give us
Mr.
your name.
Chairman. I notice former representative mentioned she had served under Governor Jindal. Well, I served under Governor John McKithen, Edwin Edwards, Dave Treen, Edwin Edwards, Buddy Romer, Edwin Edwards, and Mike Foster. So it's a pleasure to be with you guys here. I feel like I'm worn out, though. You know, the bill has been changed, but as I understand it, the most important aspect of it to me, after having reported in the family court and attended many family courts, I'm very concerned that the actual transcript may not always represent what actually was said. And this is why an audio recording is so important, because it's the best evidence of what was said. As I appreciated all the concerns about privacy that are stated, anybody can purchase a transcript right now. Anybody. You can put it in the newspaper. I can put it in the newspaper. Any transcript. But what we're talking about is having access to the original audio recording so that we can compare the transcript to what actually was said, because it's not always the same. There are all kinds of things that are said that really shouldn't be said. So really, that's what it means to me. That's what the bill means to me. And that's why I'm so for it, because that's the best evidence. We're all for transparency. Everybody here, we're for transparency. We're for open government. These decisions are being made in the name of this state. And it's important that something like a transcript be accurate. And we have a problem here in family court, for example, of the state law says they're supposed to charge $1.50 per page, but they're charging $6 a page for the transcript. So in federal court right now, you can get the audio today or tomorrow, right? And so if you want to go home and listen to the audio, you can do that today. You're not months from now. I'm not talking about making an appeal or someone who wants to know what happened, even an attorney who may have been there or not there. What did they say? You can right now, in federal court, you can go and listen. But it could be weeks or who knows how long before you get a transcript at great expense to people who don't have money. So to me, that's what this is about, providing audio for something that's already available, but to have it available immediate as the best example of what actually happened.
Representative Jenkins, I just have the cameras are out now.
Yeah, as I understand it, cameras are not in the
Cameras
bill.
are
This
out.
is the audio of what happened.
And Representative, you're not going to put the cameras back in on any of this
No,
process?
sir. We had understandably a lot of issues and questions about that. And so because of that, we decided that it was best at a better bill not to have the cameras, but just to have the audio.
All right, the question I have is the clerk of court or the transcriber going to do anything different if your bill passes than they're already doing?
I don't think so. No, I don't think so, no.
So there's no extra cost to the
No.
court system except the making the little,
And the fiscal note was because of the cameras, the live streaming, and so that is not applicable anymore because of our amendments to the bill.
yeah. Most of us lawyers went to school to be lawyers, not actors, and that's why cameras kind of scare some of us. But, Mr. Representative Jenkins, are you through? Or?
Yes, sir, I am. Thank you very much, sir.
Thank you very much.
Yes, sir.
Ms. Rayburn, you want to say something?
Yes, this bill is a tool to bring our justice system, specifically the Family Court of East Baton Rouge Parish, into the 21st century. Other states, like someone had already suggested, all the courts in the whole entire state. Some of the states that have their courts with digital availability to litigants is Florida, Texas, California, New York, Arizona, Georgia, Colorado, and Washington. So this is not anything new. Like Woody Jenkins just said, in federal courts and in federal proceedings, some courts you can go in and purchase a CD. Now it may be changed. Now this was like 10 years ago. You could purchase a CD and get a CD and hear your court hearing. The family, and this specific family court in East Baton Rouge, again, it's not criminal court where you would have a daddy that's been accused of horrific things to a child. It's not juvenile court, which is down there by the airport. This is the EBR family court. I've been down here for 15 years trying to get availability digitally without having to wait 3 and 4 and 5 months for a transcript because they're overworked. I have begged and pleaded that there would be some immediate access to what went on in the courtroom. The audio should be available immediately. It's easy. You upload it. There's administrative hearings. You can go have a hearing. You can upload and hear your what happened that night. There's no reason why this should not be available. It is a tool. It's a tool not only for the litigants, it's a tool for their attorneys, it's a tool for judges. It's a quick availability. A recording can be either written by hand, it can be transcribed, it can be this, or it can be an audio recording. There are, I am a federal appellate attorney. I'm not speaking in that respect, but I am an attorney, and I did work and practice at different times in the family court. The things that go on are reprehensible, and I've said this before. Some of you may have heard me before, but the things that go on, the isolation of litigants in a courtroom, even attorneys, and what is done and said is absolutely frightening. And if you've experienced it, you would not even believe what you have just experienced. And this bill and the ability to have a recording in the courtroom where you can go back and you can listen. Here's what was said.
Got 17 people.
This is what went on.
All right, Representative Green.
Thank you, Mr. Chairman. Ms. Rayburn, I'm sure that you thoroughly read this bill, and so let me ask you this. Page 2, lines 12 to 18, this statute talks about closed custody hearing, and basically it says that the custody hearing shall not be closed to the public unless all of the following occur, right? So the first prong is that the judge determines on the record that good cause exists based upon the evidence submitted, and the other condition is that all parties have to agree, right? So if the judge believes that good cause exists and puts that on the record, but if you have one parent who says, you know what, nope, I want to be in open court, and the other one says, I'd rather it be closed, as a result of that, is it the fact that that hearing is now open to the public?
According to this, if the parties agree in writing, they can close the courtroom. I'm an American. I'm a United States Constitution American, and I don't believe in closed courtrooms.
No, that's not my question to you. My question is very specific and direct. You're an attorney, right? So I'm asking you that the conditions for a hearing to be closed is that the judge makes a determination on the record that good cause exists based on the evidence submitted. That's number one. And number two, all parties have to agree. So if one party does not agree,
It's not closed.
it's not closed. That means that you, myself, or any member of the public, right, can attend that hearing.
Correct.
Okay.
And there
My-
should be no reason why that in the United States of America is a problem.
My next question is, there's nothing in here that speaks about who has access to the recording. So if a status conference is held in open court in the presence of the parties, and there shall be an audio recording, does that allow any person, any public person to have access to that recording?
You can have access to the recording. Correct. The litigants can have access to the recordings.
Where does it say that in the bill? Because I don't see where in the bill it says only litigants can have access to the recording.
Do you have the bill?
Do you have the bill?
Yeah. I don't know.
Right now, today, if you have a transcript,
My question is with the bill. Can you tell me where in the bill does it
For
say
you.
that only the litigants shall have access to the recording?
Okay. As amended, Representative Green, 1401.2, letter C, a copy of the audio recording shall be provided at cost upon the request of a party in the litigation in the family court. Does that answer your question? Okay, it's, if you're looking at it online or you're looking at it on hard copy, it's HB 278 as amended under 1401.2, letter C. It says, a copy of the audio recording shall be provided at cost upon the request of a party in the litigation in the family court.
But that doesn't.
Was that your question, Representative?
But that doesn't stop me from getting an audio recording, does it?
You're not a litigant, are you?
You can't even request one.
You really can't request
I would,
one.
if this bill happens to get out, I would suggest that you maybe add in additional clarifying language that maybe only. Only, it goes only to the parties?
So that it's clear that it can
Very
be no one
explicitly
else
clear
except
that
the litigants?
only-
Is that what you're saying?
Yes, only the, only the parties were able to access that, and, yeah,
Okay, you good with that? Okay,
thank you.
Representative Green, we'll do that.
Can you do it today?
Representative LaFleur.
Thank you so much. So that one's taken care of because it did not say only. It said a party litigant could get it, but not only a party litigant. My next question is how do you define timeliness? Because we've heard a lot of conversations about getting the recording in a timely manner.
Timeliness, is that what you said?
Yes. How is that defined in this bill? And is there some guidelines that says you got to give it up within 48 hours, 72 hours, a week? I don't see this anywhere.
That occurred to me as well, and I'm open
Yeah,
to possibly,
We figured just common sense, let
Yeah,
the family
that's what
court.
we
You
figured.
can't, you can't legislate common
figure
sense.
that, yeah.
Let's add there. And the one thing that we're supposed to do here is write it so you can follow it. And so that
Right.
not having that there, it could be the backlog that you're complaining of. Because you didn't tell me I had to have it within 48 hours,
Right.
72 hours, or a
That's
week.
correct.
It's
Yeah.
not here.
Well, Representative LaFleur, what would you suggest would be a,
I'm sure the judge has a suggestion for you on
yeah,
that.
he does, but I was
Or
asking
we
you,
can ask
24,
the
48
practitioners.
We talked about
Yeah.
that, but if you put a time limit, we don't want to overburden the family court. I mean, if they're in court all day, they may not be able to do it until the next day. But obviously, if it takes 2 weeks, that's unreasonable.
About 2 months.
Right, so you've got a time frame. It's not in the document, but you're going to want to hold the judges responsible without giving them that information
Yeah.
that they need. Are we clear on my concern?
Oh,
24 to 48, it's easy.
7
We'll
days.
definitely look at that.
Thank you so much, Representative.
Thank you.
Representative Green.
And look, I have concerns with it, and so my question is, what happens if this audio recording is leaked, right? I think I get what you want. You want transparency, right? But what happens if the recording is disclosed and, it highlights something a judge has done? What's the recourse a judge has to answer for what they've done? I mean, I know they're under tight constraints under Code of Judicial Canons. How can they respond to any criticism as to what happens?
Well, criticism
in
is
the
one
court?
thing, but I mean, you mean illegality? I mean, people are criticized all the time. I don't really understand what you're talking about. Do you mean if they did something illegal, what would happen?
Not illegal. I mean, if a party has a concern with what a judge has done or how a judge has ruled,
Okay.
right, and there's this recording out there and it leaks or it's made public, right, how can a judge defend him or herself with their rationale? Because at the end of the day, judges are politicians. They have to answer to the public for the things that they've done. However, judges are different from you and I because we are members of the legislative branch. They are members of the judicial branch, and they're bound by a code of judicial canons, which restricts
That's what I would say.
what
Aren't
they
they elected as well?
They are elected, but
Okay.
they are limited in how they can respond, right?
What would
Can
you
I
say
speak
about
to
that?
that? I have
Well,
some-
Hold on just a
as
second.
I think Mr. Jenkins said, there's the transcript's the same thing. I mean, anybody can go and get a transcript, and so that'll be that. I mean, we would hope that this would make the judges be more careful about what they do in court.
And if there's any information that's in the transcript or in the recording that is sensitive, maybe this was touched on earlier, would there be a means to redact sensitive information?
Well, no.
Because at least maybe the transcript could have redactions. And is that
No.
fair to say?
Redactions are totally the wrong way to approach. This is supposed to be an open court system. I mean, it's what. I don't
What's
know
a
what-
scenario that you're
That's-
thinking is so sensitive that it would not be?
As was said, these are not people who have been charged with crimes or even investigated by DCFS. These are people just going to court like anybody else. We're not going to hide misbehavior. That's what we're trying to prevent.
Okay.
That it, Representative?
All right. Representative Jordan.
Thank you so much, Mr. Chairman. So look, let me ask y'all something because I do have a little bit of pause when we're talking about the open court custody hearing. So I'm just wondering if you're flexible on that at all and maybe working with that a little bit. But while you think about that, let me ask this other question because it goes to Representative Green's point, but slightly from a different angle. What is the purpose of the audio? How do you envision the litigants using the audio or it helping them in some way? Or is it just for transparency purposes?
I think it's mostly for transparency. There's not a whole lot you can do after the court is over and the judge makes a ruling. You can take an appeal.
There's the Judicial
This
Commission.
is a preventative measure to try to put people on their best behavior when they're in the courtroom.
No, I get it, but I guess I would not want the and look, you could get the audio, I guess, at some point, but maybe a standing gag order that it would not be released publicly for, I don't know, a month after the court proceedings have ended or something like that. I guess what my point is, I wouldn't necessarily want one party, because these things get highly emotional, to weaponize it against another party. For instance, let's just say in a hearing, something comes out about infidelity, and then the next day you get that recording, and then the next day they go and they upload that on YouTube, or they post it on Facebook, or they do something like that, and using it for a purpose that it was not necessarily intended for. Now, again, you're right. At some point, you could get the transcript, and you could take the transcript and you could post it. We all know that the written word does not necessarily have the same effect and context as the spoken word and you hearing it. But I just wonder, maybe just as a prophylactic measure, that maybe we could use it and say it as a standing gag order. You can use it, you can listen to it, but you can't publish it for X amount of time after the proceedings have ended. And then that way you couldn't weaponize it during the course of the hearing. And then it would be, that I think that would give some protective measures to all parties, because these things do get highly contentious.
Mr. Chairman, will you take public comments on amendments?
Before they even get to court. It's already been weaponized before they even get to court.
The amendments have been adopted.
He's talking about a new amendment now.
I'm not offering it as an amendment right now. I'm just asking in concept. And so
We will definitely entertain that. I see what you're saying. I just wonder, though, 30 days, and then what if on the 31st day they want to do the same thing? I feel like we can't control people's behavior.
You can't control the behavior, but
Right.
I think you can at least.
Stopgaps in there? Is that what you're saying?
Well, what I don't want is, and from my perspective, is a judge having to deal with chaos in the middle of a trial.
Right.
And so that could create a very chaotic situation in the middle of the trial. I mean, if you wanted, look, I'm for transparency, and if you wanted to use it to listen, even to strategize how you make your next move, maybe for preparing for court the next day or at the next hearing, you know what? So be it, but I wouldn't want it to necessarily become an unintended weapon within the hearing itself.
Don't want that either.
And so that's just part of my
All right.
questioning on
You've been
that.
out of
Thank you
time.
for that.
Go to
Okay.
Representative Chenevert.
Thank you, Mr. Chair. Real quick question, and just for the record, Rep, some things were said. I want to fix any issues we have in family court. I don't think there's a person up here that is not what we would like to do, okay? I did have a question, though. I wrote it down as I was listening. Two questions. I know with our time, for quickly, I do think that, audio would be important if you can purchase a transcript today. Obviously, there's a way. It is a cost involved, so it's not.
Correct.
That is different than just being able to have an audio recording. Now, I understand that, and I'm all for transparency. But could the effect, if you are recording it, I'm just hypothetically, I'm not an attorney, I'm not in family court, you know this. Could it have a chilling effect on testimony of individuals knowing that they are being recorded? Meaning, could it on either party? I'm just asking a question. Is that something that, do you think that is any concern?
My concerns about what's going on override
Being live, I'm saying, like being in the public, right?
No.
Secondly is, I don't want to, for me, it's not like we want bad behavior. You want that to be revealed. I think sometimes it's not just, again, I don't know in every case, but let's say if you have a businesswoman or a businessman and there's a lot going on in court and all that is being publicly displayed. Now, just because of what's being displayed publicly, it has nothing to do with their business and all those things. I'm just trying to think of all these scenarios. Does it work against them? Is it something that, is there a way that we write the bill when it deals with, I'm just thinking about all these scenarios that everyone's personal life is all out there, and you're talking about your financial, you're talking about where you take your kids, I drive them here, I don't know what kind of questions are asked. As a mom, I want to protect kids wholeheartedly and families, but I don't know the answer to that, and those are just some things that I have concerns about. But I believe in what you're doing. I'm just trying to navigate how do we do that without making sure that everyone's personal life, their businesses, where they drive to drop their kids off at school as they're talking, and people, it's all out to the world. I don't know. I'm just throwing that out there. Just, those are some concerns I had, and we had talked a little bit, but not much until today. So y'all feel free to answer, or I can ask people later.
Do you have an answer for that?
You can get a transcript. Those things will already be known, can be known. This makes, instead of waiting for months to get a transcript, you can hear what went on today or tomorrow. You can upload it and you can hear it. There is all kind of ways. There used to be a way that your attorney could go up to the courthouse, make an appointment, and go listen to the little tape and sit there and get a transcript. They used to have that. Then they didn't have that anymore, and they've changed a lot of this. We are now in a digital age where it's very, very accessible. All you have to do is record it and upload.
We're gonna
Okay, thank you.
have to ask y'all to y'all been
We
up there
get it,
too long.
yeah.
I got
I
12
know you've
more
got
green
cards.
cards
I know,
to go
yes.
through. The next one up, Catherine Diamond, Dong Lam Tram, and Michael Rawl. Please, y'all can, however y'all want to go, just say your name and who you represent.
I'll go first. My name's Michael Ryle, and I'm in support of this bill because transparency in family court is very important. No one should have to go through what many experiences in family court. In 2023, I had a hearing where my attorney had prepared filings and was confident going in. Before the hearing began, she went into the chambers with the judge and opposing counsel. When she came out, her demeanor had completely changed. She looked scared and asked, "Are you sure you want to proceed?" warning me they would take custody for me in the end. Decisions were made before any hearing. A few months later, I was sent to another attorney who said, you need to hire me to even out the playing field between the judge and the opposing attorney because we're all best friends. From there, I was told about dinners the judge and the attorneys were having, discussing how to proceed with my case. Each time I was told the judge did not like me. Certain pleadings on my behalf were not filed because she was concerned it would further annoy the judge. The record was just kept just the way they wanted it. At these dinners, they would talk about what witnesses they would allow to testify and not testify to portray the record how they wanted it to reflect. These are serious matters involving families, and it should not be treated like a game by some. Transcripts alone is not the answer. In one of my hearings, the transcripts did not state what was actually said. It may have been a mistake, but a small mistake can be negative consequences. This bill ensures proceedings are recorded and available, and that the status conferences occur in open court and creates a clear, reliable record of what happens. It holds everyone accountable and protects everyone involved, parents, children, attorneys, and the court. And as we sit here today, all of us are comfortable being recorded right now. So I don't understand why family court has to be a closed-door policy and not open to everybody. And backdoor dealings do need to stop. You mentioned how's a dinner going to stop with this. I can't give you that answer. But the children need to be protected through this process, and they're not protected here.
Ms. Tram?
Thank you for giving me this opportunity to speak today. My name is Dong Lam Tran. I'm currently have an active matter before the family court with docket number 203415 in Division C. I am here today to bring to your attention certain statements made by my former attorneys, Mrs. April Bouchard and Mr. Brian J. Pendergast, which have caused me concern regarding the advice and guidance I received during my case. On May 31st...
You can't talk about a case that's pending before the court. We're not judges. So you can talk about the bill and whether you like the bill or not, but don't tell us specifics of a case that's pending.
Yes, sir. I So you want me to not mention the judge's name and the attorney involved with it?
That's not what we're here for today.
Yes, sir. I just want to. The experience, not detail of the case. So I will leave the attorney name out and the judge. Thank you, sir. On May 31st, my attorney pressured me to sign documents claiming judge would not grant me custody of my child unless it was split 50-50, and assured me it was a temporary custody schedule and could be changed later. That was 10 years ago. In the summer of 2023, my attorney informed me that judge did not like me and advised that if I made the judge hear my case that day, I would be held contempt and she would put me in jail. My attorney makes similar statement again in November 2025, indicating that the judge did not view me favorably and that I would lose custody of my child if I forced the hearing to continue that time.
Ma'am, let me ask you, did the judge tell you this in open court, or how were you told this?
I did not hear this from the judge, but my attorney came out after the conversation behind the closed door with the judge, both attorney.
Said
he
you were
came
held
out.
in contempt?
Yes.
They
yes,
had
sir.
a contempt hearing?
Yes, sir.
All right, so there was a hearing about what you did. That's all I wanted.
There was no hearing in the court. It was backroom deal, and my case would not be presented at all. He came out and he told me what the judge was saying about me, and he also makes statement that the judge didn't like my post about the family court. And it just, my case has been going on for over 10 years, and I have not had the opportunities to present my case in the courtroom.
Ma'am, you want to speak?
Yes, thank you. I am grateful for this opportunity to communicate with y'all. I think it's very important. I'm sorry, my name is Catherine Diamond. And my name is Catherine Diamond, and I would like to discuss the importance of, transparency and being able to verify what goes on in these courts. In 2019, I went to trial on a motion to modify custody filed by Karen Downs. Before the hearing,
Let's give our attention to the speaker, please.
Thank you very much. Before the hearing, my attorney told me I had to stipulate because Judge Baker did not like me.
We don't want to get into names.
I'm sorry.
Of attorneys or judges.
Okay.
We're here to talk about this
okay,
deal.
I'm telling you, I went to court and I was told before the hearing, before I had a chance to present any evidence, all that had been done was a motion was filed by my ex-husband, which was largely concocted. And I was told before I had the opportunity to defend myself and to speak on the matter that I needed to stipulate to losing time with my children because the judge did not like me. I was perplexed. I could not understand what he meant because I didn't know the judge and I didn't understand how that fit in with the law. So I insisted that I go forward with the trial because I am a good mother that loves her children and I wanted to defend my family. During the trial, the trial opened up with the judge telling me that she had sentenced people to what amounted to 2.5 years in jail for contempt. And based on the allegations, the false allegations that were being made against me, that would equal 7 years. So I was a little bit put off to begin with because I was being so, because these family court consequences for these allegations by my ex were so serious. So I was, presenting my material in a factual, professional way, and during the recess, my attorney told me that the judge was rolling her eyes the entire time while I was speaking and warned that I would lose more time with my children if I didn't go ahead and give in to what the opposition wanted. This is not legal advice. This is intimidation. And then later, my father and I went and interviewed different attorneys. One of the attorneys told my father and I directly, "You cannot win in this judge's courtroom with the other attorney in the opposition." And so she offered to represent me for free to walk me through my demise, which I declined because I love my family. Could I please continue? It's very short, and I feel like I spent a lot of my time trying to accommodate your request not to say names, and then when you ask people to be quiet, I have a very short amount left. Would you mind if I finish? Thank you so much. I declined because I was not looking to surrender. I was trying to protect my children. In 2020, I suffered false allegations of domestic violence, which were never investigated or anything. They warned me if I fought it, the judge would place me in a permanent protective order, even though there was no evidence of abuse or injury at all, just my ex-husband's words on a piece of paper.
Ma'am, you've gone over, and you're not talking about the bill.
I'm talking about the need for transparency. They're making backroom deals. They're deciding things without any type of due diligence. They're just basically doing things that are very suspicious and very wrong, and there needs to be oversight. I mean, in one case, in one court date, the judge was having ex parte communication with the attorney, and my attorney asked about it, and the judge just, whenever she asked about it, just blew up into expletives. I mean, it was shocking. I've never seen anything like it before in my life.
You're over now, and we've got to get some more people to testify. Thank y'all.
Thank you.
Dr. Scythian Strother, Elizabeth Fox, Lane Hudson, and just remind you that we're not here to hear about your case in particular. We're here to hear your comments on the bill.
Who should go first?
You can go first.
Okay.
Give me your
All right.
name and who you are.
All right. Thank you, Chairman and members of the committee. My name is Kristen Lane Hudson, and I am here today as a mother on behalf of my two children, Jack and Hugh, who were taken from me via an ex parte hearing, which was a result of closed doors and conversations. But I have not seen my children or had any meaningful time with them in 5 years now. And this is from our court right here. And I can definitely tell you that HB 278 is not, it is imperative that this be passed. I have felt like I was in a different country. I stopped believing in America and God, and it was because of the way that we were treated over there. It is criminal. I would appreciate all of our representatives to please pay attention, because without it, our kids are not safe. They are not. And it's like, I am so grateful for Judge Hughes and Representative Edmondson, because they listened, and Woody Jenkins, because it is very difficult to get people to listen to you and believe you when you have attorneys and prominent judges saying that you are crazy or that you have done something wrong. My kids were taking on false allegations that were easily disproven, and I have still yet to have my follow-up hearing in court.
All right, thank you.
Mm-hmm.
Who's next?
I'll go next. My name is Elizabeth Fox, and I'm a family law attorney practicing here in Louisiana and in the family court. I represent Ms. Crystal Lowe in Baker v. Lowe, which you may have heard about.
We're not talking about cases.
Right.
We're not here as a judicial panel.
I understand.
We're only here about the representative's bill.
Correct. You may have heard about the WBRZ story that aired a couple of days ago.
No, we don't want to hear about.
I'm not going to go into that, I promise you.
All right.
I'll keep this very brief. We appeared in the family court on March 24th, 2026. We had an off-the-record status conference during which I was threatened with a bar complaint for, among other things, refusing to disclose Ms. Lowe's address, despite citing confidentiality and safety concerns. There's no transcript of that exchange. There's no recording. There's no way for any reviewing court to evaluate what occurred. These aren't abstract concerns. They are real consequences of proceedings occurring off the records. What is happening in this case is not unique. It's the result of a system that permits substantive discussions to occur outside of the record without accountability and without any reliable way to preserve what was said or done. House Bill 278, as amended, directly addresses this problem. It requires that status conferences be held in open court in the presence of the parties and that an audio recording be made and provided upon request. That matters. It means there's a record. It means there's accountability. It means that proceedings affecting custody, visitation, safety, and fundamental parental rights are no longer confined to memory or to competing narratives. While the bill no longer includes live streaming or broader public access, it establishes a necessary baseline. It ensures that proceedings are preserved and can be reviewed if needed. And for those reasons, I support House Bill 278 and respectfully urge its passage.
Ma'am.
Yes. I'm Dr. Siobhan Trotter. I'm a doctor of nursing practice, board-certified nurse practitioner, and former manager of clinical research quality assurance. I trained through programs affiliated with the Mayo Clinic, Arizona State University, and I am experienced in evidence-based practice, clinical standards, and applying protocol to complex high-risk situations. Over the last 4 years, we have been, as grandparents, taken through the system. It's cost us over $300,000. There have been every single situation that has been mentioned here, so I'm just going to go off script. Every single situation that has been mentioned here, backroom conferences, where a hearing is set up, you go to the hearing with your witnesses and all of a sudden it gets switched to a backroom status conference. There have been at least 4 ex parte filings on us and no rule to show cause. It's a requirement by the Supreme Court. There have been multiple conversations ex parte between the judge and the politician father of the child's father. This bill doesn't even touch what needs to happen in family court. I think, guys, we need to really look at this, okay? So I could sit here, record our whole conversation, and in about 5 minutes, there's a program right here. It's an Apple program. It'll spit out a transcript for me.
Exactly.
We are now in 2026, and we really need to look at changes to the family court system. I am a mandatory reporter. I have been ordered by a court in the state of Louisiana that at penalty of losing access to my granddaughter, I'm not allowed to report no matter what I see or hear. We have gone through 4 years of this where, yes, 4 years I have been told if anybody else reports, I'm losing my contact.
We need to stick to the bill. I still got a lot of people want to.
Okay, I'll just wrap up. What I can tell you is that this is just a start. You don't need to worry about transcripts. They're not redacted. You don't need to worry about recordings. It's 2026, people are going to record things. We just have to make some sort of effort to have some transparency, because there are bad deeds being done in our court system. And on top of it, we really do need some investigative efforts around how this is happening, particularly with respect to children that are potentially sexually abused.
Representative Mack, you got some questions?
It's for the author and the Justice Hughes.
Well, that's passed right now. Okay. Representative Owen.
Real quick, ladies, all I want to ask is what y'all are seeking is equal treatment under law, right?
Yes, and due process.
It doesn't sound like your perception that this law seeks to address is giving it, right?
Well, it's one step, in my opinion.
It would offer protection from...
Some protection.
And it is, like, I'm not a lawyer, so I don't understand a lot of that stuff. But it seems to me is that when you come to a roadblock in the law and you wish to appeal it, if there's no record of anything, you have nothing to appeal on.
Exactly.
These ex parte things that go on, I know that happens in law, but that doesn't sound fair at all for people who are being kept out, especially in one of these things. So that's all I want to know. Y'all are seeking equal treatment under law.
Yes, sir, Repo, and that's precisely it. Things that go on off camera and not being recorded
Children are
determine the
being
course of our
trafficked.
cases.
Representative Landry.
I have a few things to say, then I have a question. Equal treatment under law is provided in a courtroom, not in our hearing. No, that's where it is. That's why we have appeals, writs, motions to reconsider, the whole 9 yards. What seems to be happening here are some very sad, contentious family situations that people are trying to relitigate in here.
That's not correct.
You don't get to interrupt me. People are trying to relitigate very sad situations. We are not the proper place for that whatsoever. Most of the people aren't talking on the bill. Some people are. I have my colleague here confirm again, every proceeding with a juvenile, I think everyone, or almost everyone, is a closed courtroom, and that's for a reason, because there are children involved, and they come first in this situation. It is not true that there is not any evidence. There is a transcript of everything. I understand that it's expensive, but they exist for a reason. You can nod your head, whatever. They exist for a reason, okay? That's why they exist. That's why we don't have recordings.
Too much. We couldn't afford them.
Robbie, can you remind the witnesses that I'm the one speaking, please? Rep. Carter, I'm sorry.
Yes.
Right. There's a reason that we don't do this. Otherwise, we would have in 64 parishes exactly this situation, and we wouldn't be here doing it. And that's because there are children involved. So my question is, if we have this recording and somehow it's confidential and not leaked, and it's not sent out everywhere, what's going to happen? What are you going to do with it then?
We don't want that. I mean, I would have liked to, personally, my ex-husband left me and my children, and I went to the family court in 2019 and am still here and paying my ex-husband child support, and I have not been able to see my children in 5 years outside of a supervision center where I can see them for 47 minutes and pay $50. And so this is offering an opportunity to put some accountability, and, you know, people do speak differently. They are going to act differently when they know that they are being or can be monitored. What's going on in there right now is not American. It is not. And the way that they treat you is awful. It is a matter of life and death. There have been, if you want to protect the children, you have to start with the parents. I mean,
I have a question.
Can I finish?
You go ahead.
Yeah, I still don't see how this would change anything. You have a very sad situation you just described, which several people are here to relitigate their cases. We don't do that.
I am not trying to relitigate my case. I am trying to get my children back and avoid any...
You don't do that here.
No, but I am trying to avoid anyone, any parent, any child in the future from having no meaningful relationship.
How would this change it?
How is it that you cannot advocate for...
How would this change it?
It would... I just answered your question, ma'am. And I said it would offer
How would this change the
accountability.
situation? Would you go to court with the recording then? Or what would you do with the recording?
Ma'am, I've never been on record because they did all of my hearings in closed doors. My attorneys then came out and told me what the deal was. And I started.
There is a record. What would you do with this recording? If your next hearing, let's say,
I might
you
want
have
it to,
one.
like,
What would you do with it?
I have been in the family court system fighting for so long. At this point, we've got to change some laws. We are living and functioning with an antiquated system that was designed for 1950s, and we are in 2026, and we have AI. We could save, it is much more, it's much more reliable than the
Just for the
humans that are
committee
over
to know,
there.
that's good. Just for the committee to know, we have not had one person here say how this would change anything, any situation.
provides
Literally.
accountability.
I can tell you.
Hey guys, okay. You speak when we answer a question, okay?
Okay.
And I'm done with the questions and I'm addressing my committee members. We have not heard any reason for how this would change anything. I've heard the word deterrent. I don't know if I agree with that, how it would be a deterrent to a judge to change their mind. I don't know if that's what people mean here, but to avoid the fact that we're going to have children's private business out there because some parents are not happy with the situation. That's the opposite of what we should do as a committee, and I'm really bothered by where this hearing is going.
I am really bothered that you are a public servant.
We are done.
Brandy Seals, please.
Okay.
Brandy, you're the last one of the green cards to testify. Then we got a whole lot of red cards.
Okay.
Oh, yeah.
Good afternoon. My name is Brandy Sills.
We don't want to hear about your case. We want to know what the bill does.
Yes, I'm here to advocate for this bill. I have the same exact story as all 6 of the people that had come up here before. There does need to be transparency in courtrooms. There are way too many backdoor deals. There's a lot of, status conferences. And then they're coming into the hallways and forcing parents to sign things that we never even were prepared to sign. Not even just being prepared to sign, but being threatened to sign. And our attorneys are coming out and saying, well,
This is not about the bill. Talk
well, then
about
how do
the
you get
bill.
transparency in the courthouse?
All right.
By passing a bill for transparency.
All right. Are you proposing that they do all this audio back in the judges' chambers when the attorneys meet?
Absolutely. That's where all this is going down.
Because I don't
Well, maybe
think
they
that
wouldn't.
is-
Maybe
I
there
don't
would be
know
so
if
much
we're going there
corruption
with
in
this
family
bill.
court.
All right, we've got some red, that's the last of the green cards.
Thank you for your time.
Thank you. Teresa Broussard, Lenny Brailsford, Wendy Edwards. They're all got red cards.
Representative Carter, can I yield to the judges at the family court first so y'all may ask
Nope.
them some questions?
No, the rules are, the green cards go first, the red cards go second, the white cards go last.
Also, Miss Teresa's not here, so if y'all wanted to call somebody else, she had to leave.
Who?
The first one you said, Teresa Broussard, she's had to leave.
Oh, Ms. Broussard did?
Yes.
All right. Then Vincent Safodi. Please state your name and your.
Good evening, committee members and Mr. Chairman. My name is Linnea Brailsford. I'm a Baton Rouge family law attorney. Today, I'm asking you to please vote against House Bill 278. Family court is already a very emotionally charged place. Litigants are dealing with divorce, custody, domestic violence, and today I'm asking you to think about the children. Every day we as attorneys focus on the best interest of the child factors, and so our focus is on the children. Making audio recordings in family court accessible to the public is not going to be in the best interest of the child. Imagine that you're a child and your parents tell you that they're going through a divorce and now it's getting nasty. very contested. It's hard enough as it is as a child to hear that your parents are getting divorced. Now you're thrown into the mix of it. But now, if this bill passes and these recordings are available to the public, now your friends, your classmates, your neighborhood, your bullies at school, they all have access to this. They have all of the details of what's going on in your case, your parents' case, but you're a part of it. Dad's drinking problem, mom's drug abuse, any physical abuse details, all of that comes out in a custody situation. Now all of this information is public. And as we know, now in a new world of social media, now it's on Snapchat, now it's on Instagram. Now it's being shared between one cell phone to another at high school. This bill proposes a closed custody hearing, but only if a judge determines good cause and that all the parties agree. As you can imagine in a family court proceeding, especially with a divorce, parties are there because they do not agree, okay? So it just takes one parent to say, nope, and now there's open access. Representative Schoenberg brought this up as well earlier, that this bill is also going to have a chilling effect on testimony. I would also like to say it's going to have a chilling effect on domestic abuse cases. Sometimes, and I'm not quite sure where the confusion comes in, but it feels like domestic abuse and violence is not necessarily always thought of as being in family court, but it is. On Wednesday mornings, there are so many litigants in family court, all there because of domestic abuse cases. And I feel like sometimes these domestic violence victims would sit and stop and think twice now about testifying against their abuser. Because with this bill, the public will now have the details of their rape and of their case.
Good evening, representatives. My name is Vincent Saffioti. I am a board-certified family law specialist. I've been practicing in family court and in the family courts of this state for 33 years. I'm also a member of the Law Institute Marriage and Persons Committee. This is what I do and all I have done for the last 33 years, and I will tell you that this bill is problematic. We need to take it back to the bill itself. No one has discussed, why is this targeting family court in Baton Rouge only? Why is this, if it is in the interest, as so stated, transparency regarding the children of this state, why is there a two-tier system? If I live here in Baton Rouge, my hearing is open. If I travel across to Prairieville or some other city out of parish, there's a different standard. That hearing then becomes closed and the court has discretion. Why are there two different standards? The Civil Code states the legislative intent that a custody hearing may be closed. Why do we close those cases? Because oftentimes there are allegations of abuse. Do you think, honestly, that in that custody case, the woman who has been subjected to physical abuse, sexual abuse, or we're talking about a child sexual abuse, that that person is going to speak freely, knowing that audio can be made available and that it could possibly be leaked? A transcript is completely different than an audio. So there is a very real chance of that audio being leaked. Again, why are we treating East Baton Rouge Parish different? The Supreme Court issued their report. 6 out of 7 justices agreed and signed that report, finding no abuse in the family court in Baton Rouge. When that wasn't good enough from the authors of that bill, they came back with these suggested changes. But these changes aren't to address anything that any report has ever found wrong with family court. And I want to make something very clear. I practice in all of the surrounding parishes. Those parishes all follow the same procedure. They all have status conferences. They all talk to attorneys in chambers. They all discuss the facts of the case. They all have the power to close those hearings. There is a consistency how those other district courts handle family cases, and family court is no different. This is a bill trying to target family court here in Baton Rouge and to produce a result that is just not justified. There was nothing in the report that suggested this needs to be done. Open hearings are a danger, and there's a reason why we close that. The same thing for status conferences. Judges can, thank you.
Good evening, committee members. I'm sorry. Wendy Edwards. I'm also a family law practitioner attorney here in East Baton Rouge Parish. I actually clerked for one of the judges when I first got out, and so I think it picked me more than I picked it, but here I am. One of my concerns about this bill is, I think as Representative Green said earlier, is we're trying to change what we've constitutionally given to the Supreme Court to do. The Supreme Court is in charge of doing district court rules, appellate court rules, and judicial canons even. The judicial canons 3A9 prohibits judges from allowing audio recordings in a courtroom. Now, that was more for when it was live streaming, but still, it prohibits it. So you're going to have to change the judicial canons. Then district court rules, appellate court rules, they have rules about how you can have audio recordings and what can be done with those audio recordings. The audio recordings themselves, sure, I gave it to a USB. You know what you can do with that? I can splice it up, I can change it, I can make it say something else, and I can then, like they said, disseminate it to everyone else. When we're talking about family court cases, we are talking about a child's HIPAA-protected mental health records, a party's medical records, their social security numbers, their finances, their tax returns. All of those things happen in family court. It is open. Somebody could come in and take notes. I can't prohibit that. But giving access to audio recordings where you get it and somebody could change something, you have a case where mom and dad are talking about their 15-year-old child and she's gained some weight. Okay, well, before the kid comes and testifies the next time, let me go home and let you listen to your daddy said that you were fat. There's so many problems with this bill, but the biggest one is, I agree with what Mr. Saffioti said, is why are we treating children and parties in East Baton Rouge Parish different than everybody else? I also, the other big issue I have with this is that the Supreme Court has a plethora of jurisprudence that says you should not have testimony of a child in front of their parents. There's Watermeyer, Folse versus Folse. There's even Maryland versus Gregg, which is a United States Supreme Court case, especially when you're talking about incidences of domestic abuse, sexual abuse, any of those things. There are reasons that a judge would not want the children to be in front of their parent who they're testifying against. So you're going to legislatively overrule that too, because that is something nobody has brought up in this bill, but it's in the bill that you have to have it in chambers, but in the presence of the parties.
Thank you, Mr. Chairman. Hi, my good friend Vincent Saffioti. So, how you doing today?
I'm good, and you?
Good. So, look, I hear what you're saying, but I do think you've opened up the door for a different question. And I know the witness after you spoke, and you're asking, well, why do we have this two-tiered system? How many family courts do we have in the state?
We have family courts in East Baton Rouge.
Actual family court.
And we have them in
we have.
I think there's only one family court. Hold on, no, let's just answer the question. There's only one family court, so let's go back to that.
Good.
We could make a one-tiered system and just get rid of family court if that's what you guys would like. And we could just have a one-tiered system. You're saying why family court here and then why not in Prairieville? Well, there's no family court there. There's no family court in West Baton Rouge. We have hearing officers and different folks that carry on that function. But I think simply whether you're for or against this bill is a different question. The question of, I just think it's a little bit disingenuous to say, why is it family court when it's the only one in the state.
I actually disagree with you on that because there are courts acting in a family court capacity when they're hearing a domestic case.
But not family court, though. There's no other family court.
So if the two judges in Livingston that do family law, Judge Cash and Judge Oglesby, all they hear is family cases, those are family courts. You can play semantics with it, but they're family courts.
I understand what you're saying.
So I disagree with you. We have divisions of courts, district courts, that do strictly domestic cases. And I don't care if I'm in front of a judge that is a general jurisdiction judge. When they're performing the role in a custody case, regardless of that case should be just like every other case again across the state. You don't cross the bridge and all of a sudden that child has to testify in front of his parents, but across the river, he doesn't have to testify in front of his parents.
I understand what you're saying, but again, and let's use that because, of course, I'm from across the river. So in the 18th, we have hearing officers, but we don't really have a family court. So, I mean, and it works out well. Works out fine. I think part of what I've heard from the testimony and even from the judge's report, even in talk, and I'll save this for the judges, but the overuse of contempt and some of those other issues, I don't know if you have those issues in some of these general jurisdiction courts. Maybe you do. You've been doing this for 33 years. You've been doing it all over the state. You could answer that somewhat better than me, but I can tell you in my experience, I've not seen it used as much other places as I've seen it used in East Baton Rouge. So we just need to make sure that we can have transparency, but still protect the rights of children. I agree with you on most of that. Thank you.
Yes, you said 33 years. I think the three of you together probably have the better part of a century of experience in family law. I say that as someone who's been practicing 20 years myself. And this is why we go to experts because, I'm sorry, what was your name again?
Mindy Edwards.
Yeah, you're the first person to raise what is now to me the most important issue, to force children to testify in front of or the parent to hear after what they said. I mean, I can't even imagine how abusive that would be of the system, and they would use this throughout the state to force that kid to testify in front of them and not say what's been happening about them and the parents. So number one, that's why everyone needs to vote against this. I mean, that is a horrible conclusion. And number two, my general question is, y'all have been doing this so long, what's going to happen? If you have a client or the other one, maybe your client who's not happy, gets that recording, what are they going to do with it?
They're going to use it as a tool, a weapon. I mean,
Abuse.
So, I mean, it depends on what client you have. I mean, obviously, you've got good clients and bad clients, but some of your clients or the other side, they have the ability to go and use part of it and not all of it. And then what are you supposed to do? You're the attorney, especially if you're the attorney for the other side. You're going to go on Facebook and start arguing with your opposing client in a public forum. There's no way for you or your client to come back and answer how that should happen.
And that doesn't even, to me, it doesn't do anything for the case. It causes friction. Maybe it gets some people to sit down and be quiet or not, but I don't see how it changes the case for the better ever. I mean, I just can't think, I can't really think of what this would do to improve family court.
Well, and let me also say this. I think the issue with some of the transcript cost and stuff, I think some of that is being
we can address that.
Y'all have bills about that right now, correct? In this session? About transcript cost?
Representative Muscarella.
Yeah,
Okay.
so I mean, I think that
But that's a money problem,
so
you're
I
right.
think that there's, and I understand the money problem part of it, because trust me, I do. But also with the audio recordings, it's, like you said, how long do you have it? They want to say that, okay, only the parties can get it. Well, so can the attorneys get it or can the attorneys not get it? But it doesn't say that.
But what do they do with it? Besides try to shame someone? I'm missing that
If you
too.
wanted to make sure that the transcripts themselves have to be certified by the court reporter.
Right.
If you have an issue with the transcript itself, you need to, I guess, I don't know what you do, but file a complaint saying, hey, this doesn't match what was said. And look, I've gotten a ton of these things. Sometimes I know they said cannot, but it says can.
Thank you.
Good evening. You hear two sides of a story. And you know what I always find? The truth is in the middle. And that's your point of view, and that's, I'll say, the victim's point of view here in this room. I'll tell you this, I'll agree with you. I don't know why it's just East Baton Rouge, because I get contacted all the time about the brokenness of family court. And ever since that gentleman back there went ahead and put his open letter out, and I ran a bill for the 15th JDC on commissioners, which has nothing to do with this. People are like, thank you for doing that bill. Go fix family court next. The social media comments, go fix family court next, brother, because that's where you need to go focus your attention next. I'll be honest with you. I don't think that this is the mechanism to fix it. But as practitioners sitting in front of us today, if you don't think you don't have a broken court system, you're wrong. Because you do. You worried about kids' lives? Well, you know what? Breaking up families, taking parents from ability to see their family, their kids, finding reasons to not have backroom discussions that affect people's lives. That ain't easy either. And so you want to hold yourself to be held accountable like I have to be held accountable here? Sometimes we have to understand that the system is broken and we need to figure out a way to fix it. Now, do I agree that this legislation is probably the place to do it? Probably not. But I will tell you, whether this gets out of here or not, family court has been spoken about for many, many years across the state of Louisiana, that it is a broken system that needs to be addressed. So I say to you one more time, there are two sides of the story. The truth is in the middle. If we don't solve it here today, I tell you, we're going to have to figure out where to find that truth in the middle, because this has got to stop.
May I respond just briefly?
You're more than welcome to. It's your time.
One of the things that I think has been said a lot is about the bench conferences or status conferences in the back. The Supreme Court opinions that came out about East Baton Rouge Parish Family Court specifically said that holding discussions, including status conferences outside of the party's presence, is standard practice throughout the state, and it is used to move cases forward. So the Supreme Court already said that's what's happening in every other place. I understand what the issue is. A judge in a status conference can't make any kind of order. What is happening is people are coming out and saying, look, the judge said, if you want to avoid trial, this is how we are going to do it. And people enter into stipulations that they feel like they have been forced into stipulating to. That is the issue. It is not necessarily the practitioners or the judges that are necessarily making things wrong. I'm not going to speak for every case, okay? There's always a bad apple out there kind of thing. But it is the issue that you come out and you're told by an attorney, look, if you don't want to spend this money, this is how we're going to do this. And you can either take the deal or not. That's on you. But I agree with you. I don't think this is the proper avenue to fix, if you want to fix family court.
But it does need to be fixed.
I think there are certain aspects of it, certainly, that people have issues with. I'm not going to disagree with that.
Representative LaFleur.
Thank you, Mr. Chair. In your initial comments, you said something that piqued my interest, and I'm trying to figure it out. And at my age, technology is not my friend. Okay, my kids teach me things, but if we're going to voice, and you talked about the manipulation that can occur, how do you ensure that that does not happen once you hand off a voice recording?
I don't know.
Because
That's my.
yeah, I'm trying to figure it out, because that's not, we certify transcripts, right?
Correct.
And I don't know that this bill addresses the voice recordings and whether, and how that happens, how you keep that in sort of the status that a certified transcript is. That if you publish that or if you made changes to that, then I've certified it. And then there's some issues associated with that. Family court, thank you for what you do, because family court is probably the toughest area of practice, because that is the lowest that a family comes to you is when it's in family court. And not a lot of people want to do that because it's not the glamorous life. So I'm not here to beat you up for doing your job. I want to thank you because you're representing clients. And if your clients weren't happy, you wouldn't be doing the work. Thank you.
All right. Let's see. Let's get another crew up. Y'all.
Thank you. Thank you.
Oh, all right. Representative Mack.
I apologize. I didn't catch your name earlier. I thought I heard you say you were a practicing attorney in multiple JDCs.
Speaking to me?
Yes, sir.
Yes. Yes.
Can you speak just a little bit about the problems that you see in the 19th JDC compared to other JDCs? Are they pretty equivalent? I mean, you've heard some of the testimony today. Are you seeing, I just would like to know your professional opinion, are you seeing the same issues across multiple JDCs?
There is some differences between the various JDCs and how they operate. Like the 18th across the river uses a hearing officer system. The North Shore uses a hearing officer system. Those courts can actually make orders and make decisions about children without even hearing evidence, and that can hold until you see the actual judge. East Baton Rouge, you have status conferences and you immediately get to a judge. So there's a difference in how custody cases move in the various parishes. But as far as status conferences and the judges talking with lawyers, and as in any case, in any civil case, whether it be family or otherwise, the judges generally have status conferences so they can learn what the issues are in the case and how they can move it forward. What's not an issue? What can we skip over as far as testimony, et cetera? So consistency on how they handle family case, I would say that they are generally consistent in the end result and how they get there, except for some have that hearing officer system interjected, which makes it a little bit different. If I was comparing Livingston Parish and East Baton Rouge Parish, they have two dedicated courts. I find them very consistent in how they move cases, which can be upwards of 25 to 50 cases on any given rule day. So status conferences help them move through that docket, and if you didn't, they'd never be able to get through those 50 cases in one day. So that cuts through so much evidence and so much talking about the small issues and lets the judge hone in on what's the issue in this case. And I think that's what status conferences do. And if you start making us do all those conferences on the record, you'll completely slow down the process. There's no way. You might as well just have a full-on hearing and the judge have no clue as to what the issues are. So I think that would put it to a grinding halt in some parishes. Like Livingston is incredibly overworked with 2 judges and far more cases than it can handle. So making that recorded on the record with the parties, because oftentimes it's just the judges and us, you would slow things down.
I'd also like to say that judges in Livingston Parish do travel. They're not just in Livingston Parish Courthouse every single day. So they have a caseload of family court cases in Livingston Parish, then in St. Helena, and so they have an overwhelming amount of cases. And so, like Mr. Sapioto was saying, it's a little different, but at the same time, it's.
How many family court judges are in the 19th JDC?
We have 4.
You have 4.
Yes.
All right, time's up. Thank y'all.
Thank you.
Morgan LeMaitre, Jeff Wittenbrink, and Scott Gaspard. We getting toward the end.
Ladies first, guys.
We got one more crew after this.
I'm ready to go.
That'll be the judges.
It's a ladies first situation because I'm ready to go. Sorry, guys. So, Morgan Lamondre, I work at STAR, as you all know, with sexual assault survivors, and I'm a practicing attorney, and the first court I ever sat or stepped into was family court. So I do have a background on that. And I am in opposition to House Bill 278. And I just want to say this is not about access. It is about control and whether the legislature can take that control away from the courts. I wrote a little something up since I've been here all day. And I wanted to say the Louisiana Supreme Court addressed this in Fisher versus Harder. Justice Hughes wrote that the legislature cannot enact laws that divest or strip the courts of their inherent power, and struck down a statute because it usurped the court's power to decide and bypass constitutional and statutory powers vested in the judiciary. And that is exactly what this bill does. Even as amended, House Bill 278 mandates that status conferences occur in open court and restricts when custody hearings can be closed. Audio recordings are not the issue. Control is. This bill removes the court's ability to decide how proceedings are conducted and when access must be limited to protect safety and privacy. And I want to say for the record that it is fundamentally unfair that we are doing this to children. Children cannot consent to their information being public, and if this committee hearing is any indication of what children would be exposed to if all of the proceedings were public, then I'm afraid we will jeopardize the mental health, safety, and well-being of the children of East Baton Rouge. So, getting to the point you all know me about, this has real consequences for sexual assault survivors. In some cases, a survivor becomes pregnant as a result of rape. In those cases, we must prove the rape resulted in the conception of the child. These are not always situations involving ongoing relationships, and in many cases, the parties do not know each other well. If a survivor wants to preserve their right to child support, then they do not terminate the parental rights in juvenile court. What they do is they go to family court to pursue custody. That means testifying in detail about sexual violence committed against them. This oftentimes includes evidence of forensic medical exams, images of injuries of their genitals, and ongoing medical and psychological harm. Under this bill, a custody hearing can only be closed if all parties agree. A perpetrator has no incentive to agree. Instead, they can fill a courtroom with friends, family, or supporters and force a survivor to testify about rape in front of a crowd aligned against them. Most people are uncomfortable discussing consensual sex in public, so survivors are being asked to describe non-consensual acts in detail and have deeply personal medical evidence discussed in open court under possible intimidation. Many will not. They will stay silent or walk away from custody or the financial incentive that they are entitled to. This would force survivors to pursue parental right termination in juvenile court, which would then mean they have to forego the financial report. I'm asking for 15 more seconds. You gave all of the proponents additional 15 seconds. Not you, Robbie. Carter, Rep. Carter.
You mean Chairman Carter?
That is and I just want to say that's a one-size-fits-all mandate that strips judges of the ability to protect the people in front of them. So there's also a procedural problem that I believe nobody has addressed. When this statute was originally enacted, you can go back and check because I did. The statute advertised that it complied with the constitutional provisions of public notice for local bills. Any since amendment to that statute also included local notice provisions. This bill did not include a local notice provision, so I think it also has constitutional implications for not being in compliance with a local notice publication. Thank you for your grace, and I'm done. Happy Denim Day.
Ms. Morgan, thank you for your testimony. I will tell you, though, that because it deals with a court, it's not a local bill.
I'm just letting you know that
I know.
It's questionable because every statute or bill that has amended this since the beginning did also have a local notice. So I'm just saying it kind of...
I'm just telling you that I had a bill dealing with at a city court that did not have to be a local bill because it deals with courts. So that's a ruling of the clerk that's been made. So
I hear you.
Anyway,
I'm just saying
I'm not arguing with you. I'm just pointing it out.
You would never argue with me. Never. Y'all have a great night. I'm going to go to the Denim Day event that has already occurred
Thank you,
2
Ms.
hours
Malata.
ago. Bye.
Scott, you want to go?
Jeff, sure. Good evening, Representative Lacombe, representatives. I appreciate the opportunity to be here today. My name is Jeff Wittenbrink. I'm also a board-certified family law specialist. I've been practicing law since 1987 and done mostly family law during that time, although I do other things. I also appear in federal court, like one of the other attorneys talked about. This bill, as amended, is about 2,000 times better than it was before it was amended. I still have problems with the bill, and the problem with telling attorneys and judges that they can't meet off the record. I've practiced not only family law, even though I'm a specialist, but I practice civil law, criminal law. In every instance, we have the opportunity, the attorneys, to meet with the judge and to talk about the case frankly and try to boil down, like Mr. Saffioti said, to get to the real issues that are the problem without some of the nuances that have to be held. You know, the problems that we've heard about today are mostly, in my perception, the issue of some bad attorneys giving their clients bad advice. There is never a time in family court where you cannot just tell your client, listen, you can go forward with a hearing. I understand that you don't like, how the judge is seeing these issues. What I'm going to tell you is these are the problems we have with our evidence. These are the problems that we have with the case. We can go forward. It's a problem with certain attorneys not telling their clients either about stipulations and what the consequences are, or not giving them the information and allowing the client to have the control of the case. That's not a problem with this system. I will tell you also that the reason I came today is that the family court in East Baton Rouge Parish is head and shoulders above many of the courts. I appear all over the state in family courts and civil courts, and we have an excellent family court in the parish of East Baton Rouge. Hard cases make bad law. That's a saying that has come out of the common law because they have to follow precedents. But here, we don't want hard cases to make bad law because we have a legislative system and a civil code. We don't want you to take a handful of really bad cases, out consulting with the attorneys that are there day in and day out, and have those cases make the law that you have before you. We have to keep status conferences in place. Now, I'm also of the opinion that back in the day, I was able to access the recording, as one of the attorneys previously said. I could listen to the recording because counsel and I may have a disagreement about what the judge said or what actually should be part of the judgment. Now, we write down all that stuff and have our clients read it and swear to it before we enter any judgments. Every single thing, no, we don't have access to all that, but that's if you think you have an appeal. So that's all I have to say about it, unless there are any questions. Thank you.
There's no questions. Thank you, Mr. Wittenberg. Mr. Gaspard.
Good evening, everyone. My name is Scott Gaspard. I am a practicing attorney here in Baton Rouge. I've been in practice 34 years, and the predominant type of case I handle are domestic cases. I have practiced in courts from Shreveport to Morgan City, from Lake Charles to Jefferson Parish, and lots of points in between. And what I can tell you is that in all of the years I've been doing this in many different venues, nothing is different. The way courts handle these cases is the same. Status conferences, I've never seen a case where a status conference was recorded unless there was an unrepresented party, and then it's going to be done in open court as standard practice. I have a huge concern about people being allowed to have recordings. We live in an age of AI and TikTok and Facebook and Instagram. And if you think some of these folks are not going to take those things and cut them up and plaster them on social media, you are deceiving yourself in a serious way. The idea that children should testify in front of their parents is fundamentally flawed in that it fails to appreciate child psychology at a basic level. I work very closely with a huge number of mental health professionals. I am a collaborative divorce professional. I designed and taught a domestic mediation course for the LSU Law School. I have worked with these folks time and time again, and my first go-to is to get kids counselors to deal with the anxiety of their parents' turmoil. If you put them in front of their parents and tell them they have to testify about things that went on in the home, That is horrific. It cannot be justified by any means. This is an attack on the family court of East Baton Rouge Parish, and there's a reason. Representative Avery, you asked a question a little while ago. You said, why is there a difference? Our court system was designed to do one thing, to keep people from walking 20 paces, turning and shooting. There was a point in time where all of a sudden we had to take that system, which only deals with people for a limited period of time, and then they go their separate ways, and we had to adapt it to a system that is future focused and not only deals with past problems, but future problems. And it is not a good system. It doesn't work for that type of interfamily conflict. It doesn't do it well. I do everything I can to promote alternative dispute resolution systems because I realize I'm part of a system that can't do the best thing every time for the kids involved. This bill will perpetuate problems. It will not fix them. It is misguided, and it is only directed at one court. If it was consistently good law, it should be applied to every court in this state, not one. Unless you have questions, I thank you very much for the opportunity to come and speak.
Questions for Representative Owen?
Question. If you think it's a question, give me a brief answer, please, sir. And again, as I said, I'm not a lawyer, but all I hear from the other folks that were here is that a law has been proposed to try to help them solve a problem. And you sound like you're summarily dismissing the notion that there are a group of people that feel like that there's a problem. It sounds like you're summarily dismissing it and saying tough or go get a lawyer. They may not all be able to afford lawyers.
I think you're missing what my comments were, sir, and you're putting forth a premise that I don't accept, and that is that they had a problem all between them that could be fixed by this bill, and their version of whatever that problem was consistent. They had not been successful in a domestic proceeding, 2-1. Now, does that mean that there's a problem in family court?
There's a common denominator. There's a common denominator. It's this court. That's all I have. Thank you.
Thank you all.
Thank you, Representative Owen. There's no questions. No further questions for this panel. I'd like to call up the last red card. Was Miss Natasha Carter-Benoit. She's present and would like to speak. Ms. Benoit, welcome to Judiciary.
Good evening. Good evening. My name is Natasha Carter-Benoit, and I am a family law practitioner, and I think I am justified in sitting here today because I practice all over this state. Last week, Monday, I started out in Orleans. Tuesday, I did EBR. Wednesday, I did Calcasieu. Thursday, I did EBR and Shreveport, and Friday, I ended up in Monroe. So I think I am justified. Representative Chenevert, while you're not an attorney, I would say that you hit the bullseye with your comment earlier. What I've heard today and when I look at this bill, I see the court, or our family court here in East Baton Rouge Parish, is being blamed for lack of client control. These people that have testified here have not said that the judge told them anything directly or specifically. They've said that their attorney came out and told them X, Y, and Z. I would also share with this board that a status conference is just that. It's a status conference. It is not an order. It is not a judgment. It is not a finding. It is a recommendation based on the facts that have been presented by the attorneys that they chose to represent them to the judge, and they gave a recommendation of what could or should be or could be done in that instance. It's not an order. They don't have to accept it. They don't even have to participate in a status conference. It is not required, nor is it mandated. They sign up. It's a voluntary effort. I have been in numerous status conferences all over this state, criminal, civil, and family. And if I don't like what they're saying, we go to trial. They've chosen the attorneys that they wanted to represent them. And because they didn't get what they were looking for, they feel as if they got the short end of the stick. They now came to this board to relitigate litigation that took place elsewhere. What's important to me is that A board was assembled by the Louisiana Supreme Court, and their findings does not support this litigation that's before this body right now. The amendment, while it makes it better, a lot better, there's still a problem. I personally sat in Monroe on Friday of last week, and I listened to litigants, my side and other side, take recordings that they had made of the children and that they had made of the other parties. And you know where they ended up? Facebook. You know what AI has done. You know how that comes across the screen. There's now a whole YouTube channel about it. The Louisiana T is there. Are we going to allow that to happen with this right now? Representative Edmondson said something. She said that once this bill passes, if it passes, that it's out there, they get the transcript, and you can't control people. Those were her words. You can't control what they do with it. You can't control people. Well, why would you seek to weaponize people you can't control with something as serious as your finances, your custody, the children's mental and emotional state? This is a disservice overall, and I thank you.
Representative Bro, that's actually Kyle Green, but
sorry, I was going to yield, give you more time if you had anything else you wanted to say.
Please, thank you. I appreciate that.
You got 3 minutes, though.
With respect to what Representative Hebert has stated, and I know he's in the 15th, I do a lot of work over there as well. Does our system need some fixing? It does all over the state. It does all over the state. I've been in front of Judge Blanchette. I've been in front of hearing officers. I've been in front of every commissioners. I've been in front of domestic commissioners. I've been in front of criminal commissioners all over this state. The whole system needs fixing. But this bill does not equate to what the issues is. This bill is specifically targeting a certain sector. And unfortunately, it's the lack of client control that is being presented. You don't always have to like what the judge says. That's why you have a trial. You get a case management schedule and you litigate your case. You get a considered decree. You may not like it, but you don't get to say, hey, I don't like the outcome, so now I'm going to circumvent the entire system and create legislation that unfortunately impacts. There's a saying in the courthouses, and most of them that I've been to, that with respect to East Baton Rouge, the 4th floor is the only floor in the courthouse where the litigants come and they are on their absolute worst behavior. That's what you get. That's what you see. You're dealing with the most emotional component of a family. You're dealing with their children, their finances. You're dealing with that emotional separation. The initial bill wanted to turn it into live TV. I'm happy that that portion of it is gone. But again, when you can't control people, you should not seek to weaponize them with things that are ultimately going to hurt the unit as a whole. Because once that stuff is out there, I can tell you what happened in Monroe, they'll never get it back. I had a child sit in the court with a Watermeyer and say how his friend played him the tape that one of his parents put on the internet at school. Is that what we're doing now? I would respectfully ask that this board deny this amendment. Is there some work that needs to be done? Yes. But this is not the way to go about doing it. If there's no questions.
There's no questions. The board is clear. Thank you, Ms. Benoit, for coming and testify. Now we're done with the red cards. I'll move on to the white cards. Let's go through some. So Kyle Russ, Judge, Family Court. I'm present and will provide information if requested. Rachel Shows, Family Court. I'm present and will provide information if requested. Glenna Sardi, LDJA. I'm present and will provide information if requested. Calyette Jackson Guillard. I'm present and will provide information if requested. Judge Erica Green, I am present and would like to speak.
Good afternoon, everyone. I am the Chief Judge of Family Court in East Baton Rouge. One of your newer judges, probably why you don't recognize me. I also have
Judge,
with me,
for the record, can you say your name for the record, please?
again, Erica Green.
Okay, thank you.
And I have with me my colleague, Judge Kyle Russ, and I have our Judicial Administrator, Rachel Scholes, who is also present. I do want to start with a little background. I'm going to try to do my 3 minutes fairly quickly. A little background about family court. Everyone kept saying 19 JDC. We are not. We are housed in the 19 JDC. We are a constitutional authorized exclusive jurisdiction court, specialty court that handles domestic matters. We have an intergovernmental agreement with the city of Baton Rouge, which is how we got housed in the 19 JDC. We service the city of Baton Rouge, and which includes East Baton Rouge Parish, city of Baker, Central, Zachary, and St. George. In addition to that, the intergovernmental agreement, they're providing us quarters, the facility. They also provide us operating expenses and city parish management information systems department. Why did I bring that up? Because the crutch of this bill has been about technology, and so that's the department and how we get utilize some of the department at the city parish. If you want to know more, city parish provides 87% of our revenues. Again, we are housed in 19 JDC, but any facility changes, any maintenance, any vendor payments, so any of the things that have to come from that fiscal note, that we may change microphones, technology, that comes from the building commission. We do not have a judge that sits on the building commission. That's the 19 JDC judges.
Judge.
Are you stopping me?
I'm going to try not to, but you turned the white card in speak for information purposes, and you need to be speaking on
I am giving background information.
I know, and I'm just only for the purposes, like for the bill. Like,
I didn't say if requested. I said for, I wanted to speak.
Okay. I'm not trying to cut you off, Judge, but keep the comments to the bill for information.
It is about the bill. So the fiscal note that you guys received was a result of information that was requested from us from a legislative auditor as well as the Louisiana Supreme Court. And if you go to the way it should be financed or funding, the source is the Court Modernization Technology Fund. In fact, the fiscal note that you guys kind of hypothetically said started or was came from, did not only dealt with live streaming. Actually, it's a single appropriation of $5 million. As of today, only $140,000 is still present. And the fiscal note that you received represents the cost of the changes that we received or were approved for in the 19 JDC. So in 2025, because someone said we are outdated, we are not. We are really technology savvy. And in 2025, we received recording hardware. There you go, audio recording. We received software refreshers, audio recording. We received recording servers, which deals with audio and software upgrades. That was in 2025. And that number that you heard in the fiscal, or read in your fiscal note, came directly from the costs associated with such. But when I said we, only 2 courts received that. Judge Russ and I did not receive any upgrades. So I started by giving you that information. I heard the buzzer, but if anyone could possibly give me 2 seconds.
Representative Green.
Per witness, ma'am.
Okay.
Per witness. So I'm going to let the judge.
Thank you, Representative Green. Continue, Judge. But
So
Judge,
when there was questions about how many, we did receive upgrades but we are still in need of 2 courts to receive additional upgrades to meet the audio recording needs that you guys are suggesting in this bill. 4 judges, 15 full-time employees, 2 part-times. I'm saying this because we also have 1 IT specialist, thanks to the city parish, though they're taking money from us. We are able to have our own IT specialist, which will work on these audio recordings. The court reporters and the 2-minute clerks also are the people that you guys will get these transcripts. Our judicial administrator receives the request for transcripts, as well as if this audio recording is a request for digital copies, will go through her as well, and the court reporters and the minute clerks. Lastly, there separated a lot of conversation about status conferences, so I'll jump straight there. Did you know that during COVID, status conferences was what kept the court going? It was not recorded. It was recorded via audio. And still, we have a lot of catastrophes or hurricane-related incidents that happen in Louisiana. And guess what keeps us going? Status conferences also keep us going. So this would prohibit us being able to do some of that. And lastly, status conferences help with amicable resolutions. Again, this is important because though we have status conferences, they are remote appearances. We have Zoom platforms, and we also have in-person status conferences. Again, the docketed cases that we did in 2025 are 14,908 docketed cases. Docketed events, not even cases, that's events. So every time you come in court, it's a different event. That averages 3,700 events for a division. So if we are having cases and statuses, we are trying to eliminate some of those hearings that may be 40 or so hearings in a day. And we even did in local rules address that as well. My last statement is that there are some conflicts. I think many people discuss. Our local rules are good guides that our legislators should use, though they did not communicate with us, good guides to achieve this intended goals, and also provide prohibitions and directives in violations that this bill does not provide for. What am I speaking of? For instance, our local rule addresses issues when there is a violation of screenshots and things of that nature of recorded hearings and audio recordings. It provides for I want to say punishment, but that's not the word, penalties, sanctions, and things of that nature. Again, there is none of that in this bill. It's void of that. And so if, again, we are trying to reach an intended goal, we want to support that. We want to address that, but we have not been able to do that with the bill as it sits and as it's amended. I still had more, but I'll stop.
Thank you, Judge. I appreciate it. I'm just going to ask a question. Please don't start talking. The answer is, who are y'all? Because I need to know where you sit at the table.
Judge Kyle Russ.
So Judge Ross, Judge
RUSS.
Yeah, Judge Russ and
Rachel Shows, Court Administrator.
Okay. So Judge and Administrator, y'all both signed white card saying I'm present and will provide information if requested. At this point, no one's requested any information. So, thank you. And the board is clear. At this point, all the white cards have been discussed. I'd call from Representative Edmondson to come back to the table to close.
Thank you all for hanging in there. The opposition to me just strikes me as being awfully dark and negative.
Judge, there's no more testifying. Representative Edmondson to close on the bill.
This is our close. We're going to defer.
Let me just tell him first. Okay. So,
testimony under oath, it will not be included in this bill.
Okay. First of all, I so appreciate Mr. Acting Chair and the committee. I know this has been egregious to stand and hear and talk, but this is an extremely important matter. I've spent the last year working on this, and I can promise you this is something that we need to address. Representative Hebert said it. Lots of you have said it. We know it's a problem. Now, let me just clear a couple of things up. The reason that we are looking at East Baton Rouge Family Court is because Senator Cleo Fields adopted a resolution to do just that. He didn't, the resolution didn't include any other courts in the state of Louisiana, even though, again, maybe they need to be looked at as well. We are working off the resolution. He asked the Supreme Court. The Supreme Court has done their job to look into. We've had several reports. That's why we are looking at only the East Baton Rouge Family Court. And it's the only, like I think Judge Green said, the only constitutionally mandated court in the state. So to clear that up, that's why it's East Baton. No one's picking on anybody. It's just that's the way it all fell out with the resolution, and then it was a process. There's been a lot of good testimony, and I appreciate the fact that all of you, I think, recognize that there's a problem and want to do something about it. So if you could allow us to let Judge Hughes talk just for a minute, I'm wrapping up, okay? Go ahead.
Okay. As I said, the opposition seems to
Justice
negative.
Hughes, you signed a white card for provide for information.
I will give you the information on what we want to do
But
to
it's
fix
her-
the bill.
Justice Hughes, it's her clothes. You're not a member. That's the.
Okay.
You're not supposed to testify at this point. You're not supposed to talk. It's her clothes.
Okay.
For her to close.
We're going to do recommendations. We have recommendations that we're going to do. Okay, so what we're going to do,
Thank
we
you,
have
Jess. Thank you.
we have several different things that we're thinking of, several different things that committee members have come to talk to us about. What I would like to do to keep everybody from having to vote on something that's very problematic. We all see that there's a problem. We're not sure this is the fix. So I'd like to voluntarily defer it, and I would like to ask for my committee members to help me work on this because it is something that needs to be worked on. We do need to do something. I want to be very clear. Voluntarily deferring does not mean I'm giving up on this. It needs to happen. And so I'm asking you just to please let me voluntarily defer it. And again, I thank you for listening.
Thank you very much. Thank you very much. I get it. Thank you very much, Madam Vice Chairman. Is there any objection to the member voluntarily deferring her bill? Here, no objection.
This way we can do what you want to do. We can bring it back.
We have two more bills.
Thank y'all, Chairman. And
We have two more bills, committee members.